Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Sometimes, in an attempt to be clever, we shoot ourselves in the foot. More on that in just a second. There is a legal device called a writ of mandamus, and a writ of mandamus is essentially an order to a lower court or to a government agency that they have to do something. In order to get a writ of mandamus, you have to show that you have an absolute right to the writ. In other words, that you have an absolute legal right to the thing that you want, and that there is no other way for you to get it other than through the writ. It's what the courts call an extraordinary remedy. It is often used against the state, but sometimes the state will use it in extraordinary circumstances, and we have one of those to talk about today. It involves a woman by the name, I'll just use her first name, Rebecca, who, along with a co-defendant, was indicted for felony child abuse and first-degree murder for the death of a 16-year-old child, her 16-year-old child. At some point prior to her arrest, she received help from the Missouri State Public Defender's Office, and the Missouri State Public Defender's Office sent a paralegal and an investigator to talk to her and interview her to gain facts for the attorney. Now, it's black letter law that when you speak with your attorney, anything you say is considered to be privileged. And that even applies when your attorney sends out his paralegal or an investigator. So the conversation that the woman had with these people was presumptively privileged, and it could not be disclosed. However, I suppose because of some level of paranoia that maybe the entire world was out to get her, Rebecca recorded the entire interview. And during the interview, she made statements that indicated that she was guilty of this particular homicide. So, after she made this statement and took her little recording home, she decided, I suppose, that she didn't want it somewhere where it could be found if the police came and searched her house. So she gave it to her co-defendant, who was getting ready to go make a road trip, and asked him to hold on to it. She put it in a box along with some other things and handed it to him, and he took it, he made his road trip, and when he came back, he stashed it in his closet, and he didn't think any more about it. Then, because he was also indicted in this as her husband at the time, he happened to be going through some things and he found this tape and he played the tape and he heard the incriminating evidence and he gave it to his lawyer, who gave it to the sheriff's department, and it stayed there at the sheriff's department. So the prosecutor became aware of this particular recording and decided that he wanted to use those incriminating statements. Now, he knew that those incriminating statements were made to agents of the attorney, the Missouri Public Defender. But that didn't matter because he had obtained the recording lawfully. In other words, he hadn't breached the attorney-client privilege himself. It had been handed to him by her co-defendant. So the state moved to get this into evidence, and the circuit court said, no, it's barred by attorney-client privilege. So after that, the state took it to the Court of Appeals and said, we need to get this tape into evidence, and they filed a writ of mandamus. And the state Court of Appeals said, no, we think it's privileged, sorry. So as a last-ditch effort, they filed a writ of mandamus with the Supreme Court, and the Supreme Court said, okay, We'll issue you a preliminary writ of mandamus. And it said to the judge, hey, don't take any more action in this case until you hear from us. It then reviewed all of the evidence with respect to this particular matter. And here's what it found out. Here's what the court decided. The recording was a privileged recording. She made it for her own uses. It was not recorded by a third party, and simply making the recording did not breach the attorney-client privilege. It was indeed protected by the attorney-client privilege. But not so fast, because when she gave it to her co-defendant, who was not present at the meeting, who was not represented by the public defender, when she gave that to him, she had effectively waived her attorney-client privilege with regard to that recording, because she never told him that it was secret, that it was protected, that it was privileged, that he shouldn't let anybody see it, that he shouldn't listen to it. She never took any steps to protect the recording. And for that reason, she waived the right to the attorney-client privilege. So all of those statements made in that recording are now going to be offered against her in the criminal prosecution. And that probably pretty much seals the deal on her being convicted in that particular case. This is why when your attorney meets with you and says, everything you tell me is confidential and I can't tell anybody else, you need to listen to him and believe him. Making a recording for your own benefit has no value. What would you do with it? Keep it and play it so you remember what happened, or so you remember what you told your attorney? That's not a good idea. If you have to meet with your attorney, whether it's in a civil case or a criminal case, don't make a recording. Don't make notes unless your attorney tells you to. Sometimes we will tell a client, look, here's what I want you to do. I want you to go home and write down everything that happened in this case from the first day to today. And I want you up at the top of the paper to write notes prepared for my attorney. They do that because that makes the document work product, and it makes it something that he doesn't have to turn over to the other side in discovery. So that's really important, and it's something that I think most people don't appreciate. You do not want to make any record of any conversation you have with your attorney, because if you do, there is a good chance that it can be waived. I'll give you another good example. Let's suppose you write down all of the things that you told your attorney. You know, I was the gunman on the grassy knoll in Dallas in 1962. And then you wad that up, you throw it in the paper and in the trash can, and you take your trash can out to the front, and somebody comes along and they're going through your trash can because they're looking for food, and they find this document that says you talked to your attorney and you admitted you were this particular gunman. Well, now you've put yourself in a position where you've put that document in a place where it's not considered to be securely stored. You've given up your right to possess that document because you put it in the trash and you put it out by the curb. It's not confidential. It is possible to waive the attorney-client privilege, and that's something every client needs to understand. It's kind of like the rules for Fight Club. The first rule of Fight Club, don't talk about Fight Club. The first rule of attorney-client privilege, don't talk about anything that you discussed with your attorney ever. So, hopefully that clears things up. It's an interesting story. Anytime the state rules or a state Supreme Court rules on attorney-client privilege, it's a matter of concern for me. And I think the Missouri Supreme Court absolutely got this one right. So, if you haven't already, please go over here and subscribe to our channel. Touch the notification bell so you can be notified anytime we release a video on this channel. And if you have any comments, leave them down below. Give me a thumbs up so that you can let YouTube know this is good content. And I will catch you on here next time. Thank you.